Buying a distressed property for sale can be a legal nightmare unless it's a court-supervised receivership. In this video, we go inside the process of buying distressed assets in Ontario and why the Asset Vesting Order AVO is the gold standard for title certainty. What is an Ontario court-supervised receivership? How the Asset Vesting Order AVO clears all liens and encumbrances? Why these deals are safer than standard power of sale properties? Expert advice from Ira Smith, Trustee and Receiver Incorporated in Vaughan. Explore distressed property for sale in Ontario, understanding court-appointed receivers, asset vesting orders, and key insights from the Court of Appeal for Ontario. I am the Ira Smith avatar. Right now, Ira and Brandon Smith are helping someone just like you. We provide expert guidance for buyers, owners, and creditors. As licensed insolvency trustees, the Ira Smith Team can help you confidentially review your situation and explain all available options. We are a truly family business, but we are not for everyone. If we take you on as a client, you will be treated with the respect and first-class service that you deserve. Book a free, confidential consultation. Call us at either 905-738-4167 or 647-799-3312. I hope you can watch until the end of the video and that you find the information helpful.
You know, when you hear the phrase distressed property for sale, it kind of sparks your imagination, doesn't it? You immediately picture this amazing hidden gem, a fantastic deal just waiting for you to scoop it up. But what's really happening behind that for sale sign? Is it a straight shot to a great investment, or are you walking into a complicated legal maze? And that's the big question, isn't it? It's what every smart buyer is thinking. You see the potential, you see the opportunity, especially in a market like this. But is that dream of getting a seal the whole story? Because here's the thing. The reality is, behind every single one of these deals, there's a tough story. We're talking about some serious financial hardship. And that's exactly why these sales aren't your typical real estate transaction. They need a really structured, fair, and legally airtight process to get resolved. So in this explainer, we're going to break it all down for you. First, we'll look at the dream versus the reality of a distressed property. Then, we'll get into the legal tools that actually bring order to all that chaos. We're talking about things like receivers and asset vesting orders. After that, a real-world case study is going to show us exactly how this works in practice. We'll clear up who's who, and then we'll map out your clear path forward. Okay, so what is a distressed property? Well, it can be anything. A house, a commercial building, even business equipment that's being sold because the owner is under some pretty severe financial pressure. And yeah, it can be a huge opportunity for buyers, but it is a much more complicated process. You've got multiple parties like creditors and the courts, and they all have different interests. So how on earth do you manage all that complexity and make sure things are fair? Well, the legal system has some very specific tools for that. And two of the most important ones are the court-appointed receiver and something called an asset vesting order, or AVO. So, who is this receiver? Think of them as a totally neutral captain steering the ship through a storm. They are always a licensed insolvency trustee, a pro who's appointed by the court to take control of the assets. Their job isn't to play favorites. It's to act as an officer of the court and get the best possible value for everybody involved. And what's really cool is how methodical this process is. It's not just a free-for-all. First, the receiver takes control and secures everything. Then, they bring in experts to figure out the true market value. After that, they have to market the assets far and wide to get the best offer. And this part is crucial. They have to get the court's approval for the sale, which keeps everything transparent. And finally, they distribute the proceeds to the creditors based on a very strict legal pecking order. Now, working alongside the receiver is this incredibly powerful legal tool, the Asset Vesting Order, or AVO. This is a court order that does something pretty amazing. It transfers the property to the new buyer completely free and clear of any of the old mortgages, liens, or claims. And this is the perfect way to put it. An AVO is literally a legal clean slate. I mean, think about it. Without this, a buyer would be inheriting all the old financial baggage tied to the property. And honestly, who would ever do that? This clean slate is what makes the sale possible. It encourages people to bid, and it helps the receiver get the best price for everyone. Okay, so this all sounds like a really orderly system on paper. But how strict are the courts about enforcing it? Let's take a look at a real case that shows just how serious they are about finality and playing by the rules. So here's the story in a nutshell. An events company goes into receivership. After a full 2 years of marketing the property, the receiver finally gets a buyer and the court approves the sale with an AVO. But then, way after the deadline has passed, the original owners decide they want to appeal the sale and ask for an extension. Now, how long do you think they had to file that appeal? A month? Maybe 2? Nope. Under the law, the appeal period for a receivership order is just 10 days. That's it. It's an incredibly short, super strict window, and it just goes to show you how urgent these proceedings are. So, what happened? Well, the court dismissed their motion. Plain and simple. It found their 40-day delay, 4 times longer than they were allowed, was totally unexplained and unjustified. The big lesson here is that the courts prioritize the finality of these sales. The rules and the deadlines are not just suggestions. They are absolutely ironclad. That case really makes it crystal clear that to get through this system, you need real expertise. Now, we've said that a receiver is a licensed insolvency trustee, but I know that can get a little confusing, so let's clarify the different hats these professionals can wear. It's a fantastic question, and one a lot of people have. While a receiver is a licensed insolvency trustee, or an LIT, their specific job in a receivership is very different from what an LIT might do in, say, a personal bankruptcy. This table breaks it down really nicely. See, a receiver's main job is to manage and sell specific assets to get the most money back, usually for a secured creditor like a bank. But a trustee in a bankruptcy, their role is much broader. They administer the entire debt relief process for all the creditors, and they help the person or company get a fresh start. So same professional license, but very different job. Okay, we've talked about the players, the tools, the rules of the game. Let's bring this all home and talk about what this actually means for you. Whether you're thinking about buying a distressed property, you're a creditor, or maybe you're a business owner facing these kinds of challenges. So if you only take away a few things, let it be these. First, receivers are neutral pros, there to make sure the sale is fair. Second, AVOs give buyers that clean title, which is what makes the whole thing work. Third, the courts demand finality, which means trying to appeal a sale is incredibly tough. And those legal timelines, they are not flexible. The big theme through all of this is that in this complicated world, getting expert guidance isn't just a good idea. It is absolutely essential. And I think this quote from Brandon Smith really gets to the heart of it. The court's strictness isn't about punishing anybody. It's all about protecting the integrity of the system. It makes sure that buyers can be confident, that creditors get the best possible recovery, and that the whole process is efficient and conclusive for everyone involved. And that's really the whole point of having an expert in your corner. When you're in a situation that's filled with confusing legal jargon, high stakes, and a ton of stress, the right professional can take all that confusion and turn it into clarity. They can guide you from a place of stress to a place with real, solid solutions. So if you, your business, or someone you care about is trying to navigate financial distress, please don't try to do it all by yourself. The team at Ira Smith Trustee and Receiver Inc. are experienced, they're empathetic, and they're the experts you need. They offer confidential, no-obligation consultations to help you really understand your options and find the best path forward.